Good morning, Washington State. This is Amanda Polly with DBHR, the Division of Behavioral Health and Recovery. Today, I'd like to introduce to you Marley Hochendunner from the, my brain isn't working, from the Northwest Fair Housing Alliance, the NWFHA. Today, we have the really great pleasure of talking about our source of income protections from discrimination in rental housing transactions. We all know how regularly laws change and updates are made and amendments are made, and it's a really fantastic opportunity today to be able to hear directly from the source of low-income discrimination, who's fighting against that and helping our participants move forward and create a better situation altogether in Washington State for housing. So I'd like to move forward here and introduce you to Ms. Marley. Marley, the floor is yours. Thanks.
Thank you very much, Amanda. Good morning. Happy to be here. So I want to make sure that my presentation is up and visible. Let's see here. Okay, so I'm just getting it set so that I can share my screen with you all. Okay. And there we go. Okay, so hopefully you're all seeing a slide, the title slide, source of income discrimination. Can you see that, Amanda? Are you there, Amanda? Can you? Okay, hopefully you can all see the title slide here. I'm sure if you can't, go ahead and type in the chat section and let us know if there are any technical difficulties. So I am happy to be here this morning to share information with you all about the new source of income protections in the Washington State Residential Landlord Tenant Act. And I want to also give you a little bit of an update on another amendment that was made to a Washington law that impacts assistance animals. So I'll spend most of the time talking about source of income discrimination and then conclude with a little bit of information update on assistance animals and a little review of reasonable accommodations and assistance animals. So that's the plan. I'm Marley Hochendunner. I'm the Executive Director of Northwest Fair Housing Alliance. We are a nonprofit based in Spokane, Washington. We serve 17 counties in eastern and central Washington. We get all the way over to Ellensburg. We go to Tri-Cities, Yakima, Colville, all over the east and central part of Washington. And our mission is to eliminate housing discrimination through education, advocacy, and counseling to give equal access to housing for people in Washington State. And we do that primarily through HUD grants, which allow us to provide education and outreach and advocacy for people who are both housing providers and housing consumers. And we also have some other supplemental grants and sources of income. But I really enjoy the opportunity to provide education about fair housing laws with people so that they understand the laws and hopefully can avoid any pitfalls or violations. So today I'm going to spend most of the time talking about source of income discrimination, but want to just briefly review the fair housing laws. Hopefully you're familiar with the Federal Fair Housing Act. It was passed in 1968, 51 years ago this month, and Congress passed it within a week of Dr. Martin Luther King Jr.'s assassination to try and quell a lot of the uprising and unrest that occurred after his assassination, and also commemorate his work to desegregate and open housing in our communities in this country. So 51 years later, we have the Federal Fair Housing Act, and it protects from discrimination in sales, rentals, and financing of covered dwellings. And dwellings are very broadly defined, basically anything intended as a residence for one or more families. So apartment buildings, duplexes, condo associations, homeowner associations, mobile home parks, sometimes extended stay motels, extended stay shelters. It has very broad coverage. And so I'm going to focus mostly on rental information today, but fair housing laws, both state and federal, do cover both sales, mortgage lending, financing, and any related transactions such as appraisals and inspections. So the Fair Housing Act prohibits discrimination based on 7 protected classes: race, color, religion, and national origin were the 4 original protected classes in 1968. And then the Fair Housing Act has been amended a couple of times through the years to track some of the various civil rights movements that we've had. So in the 70s, sex or gender was added as a protected class, along with a lot of the women's rights and equal pay movements. Familial status was added in 1988. And familial status pertains to having a child in the household who is under 18 or about to come into the household. So a pregnancy, foster child about to come in, somebody obtaining custody, all those things could be covered. So if an adverse action is taken against an applicant or a tenant of housing because a child's not there, but they advise that the child will soon be living with the household, and then a housing provider takes an adverse action such as terminating the tenancy, that could give rise to a fair housing violation based on familial status. So that was added in 1988, along with disability. And disability was added in the 80s with the movement to try and get people out of institutionalized living settings when possible, to allow people to live among us in our communities. And so there's quite a few provisions regarding disabilities in the Fair Housing Act that allow people with disabilities to ask for reasonable accommodations, which are exceptions to rules or policies, or reasonable modifications, which are changes, physical changes to the structure of common areas or the unit itself, such as putting in ramps, grab bars, lowering countertops, changing door handles, anything kind of physical like that can be a modification. And then thirdly, with respect to the Fair Housing Act, there are design and construction requirements. So anything built for occupancy after March of 1991 needs to meet 7 basic criteria for accessibility. And they're not hard standards to meet. It's like having reinforced walls in the bathroom so that if somebody later wants to install a grab bar, they can do so. So they're not onerous in the beginning, but if you don't build them, it can be substantial to go back and try and retrofit. So that's a third area that's covered by the Fair Housing Act under disability. So those are the 7 protected classes under the Fair Housing Act. Additionally, and you'll notice here, source of income isn't listed. So we're going to get to that, how that's covered both by our specific Washington legislation, as well as when a source of income is implicated by one of the protected classes, when it's received disproportionately by perhaps people with disabilities or women and children, or different protected classes. So in addition to the federal law, we have the Washington law against discrimination. It's located at 4960, and it covers all those same protected classes. There are a couple of differences. HUD has deemed our state law to be substantially equivalent to the Federal Fair Housing Act. Therefore, HUD contracts with the Washington State Human Rights Commission to investigate most of the complaints, the fair housing complaints that are filed with HUD. There are a couple of key differences, and I'll note some of those as we go along. One of them has to do with disabilities. Under the Federal Fair Housing Act, disability does not cover temporary disabilities or disabilities that can be mitigated with assistive devices or medications. However, our Washington state law went back and forth, the legislature and the Washington State Supreme Court a few years ago, as to whether or not disabilities, temporary disabilities, were covered, and the legislature ultimately clearly included temporary disabilities and disabilities that can be mitigated, and said this is what we mean. So the definition further of disability is very broad under our state law. It's the presence of a sensory, mental, or physical impairment that is medically cognizable or diagnosable, So any mental, physical impairment or sensory impairment that is medically cognizable or diagnosable exists as a record or history or is perceived to exist, whether or not it exists in fact. So if somebody's regarded as having a disability, even if they don't, they can be protected as well if they're treated adversely. So our state law is very broad. So somebody who has a temporary disability, perhaps a broken hip, it's expected that they're going to be recovering fully ultimately, but during the time that they are recovering, they may meet the definition of disability. So that's a difference. In addition, our state law covers marital status as a protected class. Whether somebody is single or married shouldn't factor into whether or not they qualify to access housing. Sexual orientation was added as a protected class, and although it's called sexual orientation, it also refers to gender identity and gender expression, and it covers anybody, whether they are heterosexual, homosexual, bisexual, transgender, whatever their gender expression is. All these would be covered under our state law. It's very broad. HUD has accepted under sex discrimination, gender discrimination under the Federal Fair Housing Act, some complaints in the past based on transgender discrimination, as well as people being treated adversely for not conforming outwardly to their assigned birth sex. So there have been some cases regarding gender identity and transgender status under the federal law, but not sexual orientation. But that is explicitly covered under our state law. And then lastly, as far as protected classes go, our state law, Washington Law Against Discrimination, protects military or honorably discharged veteran status. So somebody cannot be denied access to housing for the sole reason that they are or were in the military. So you'll note that source of income was not included as a protected class in either the federal or the state law. However, our Washington State Legislature chose to protect source of income in the 2018 legislative session. And they added it not to the Washington Law Against Discrimination as an additional protected class. They added it to the residential landlord tenant law. So the way that somebody who believes they've been discriminated against based on source of income would try and enforce their rights and receive remedies is a different mechanism. They would have to file a case in court with an attorney, much as they would have to for any other kind of complaint against their landlord under landlord tenant laws. For example, failure to give back a security deposit or breach of the lease by the landlord. So they would not file a complaint with the Washington State Human Rights Commission. They wouldn't file a complaint with HUD. Typically, unless the source of income specifically has to do with a protected class, and we'll get to that a little bit further on in the presentation. But source of income is protected, and we'll take a look at how somebody would try and enforce their rights if they experience that type of discrimination. So Washington protected source of income last year in 2018, and at least 14 states, perhaps more as of this current legislative session, have protected discrimination based on an applicant's source of income. Additionally, many local jurisdictions have adopted ordinances, including Spokane and Seattle. I'll show you some examples of some of the language from the Spokane Municipal Code a little bit further on, but the Washington state law would essentially trump or add potentially greater remedies than some of the local ordinances. So for example, with the Spokane Municipal Code, violation is an infraction and no damages go to an individual complaining of discrimination under that code. However, they could receive damages under the state law. Under the Spokane Municipal Code, if a fraction is assessed against somebody who violates the ordinance, then and a penalty has to be paid, but it doesn't go to the complainant. So it's a little bit different structure. But this is a growing, if you will, one of these civil rights movements is trying to ensure that people who are low income have equal access to housing, particularly when they rely upon subsidies or alternative sources of income other than employment income to access housing. So House Bill 2578 was signed by the governor in March of 2018, and it had a little bit of a delayed effect. It took effect in the fall of this last year in September 2018. Because it is so new and it just went into effect a few months ago, there are still a lot of questions about it, and both advocates and housing providers are trying to determine exactly what it covers. So let's spend the next several minutes going through the provisions of this new law and showing you how somebody what they would do, what would constitute a violation, who's covered, and what somebody could do if they want to file a complaint based on discrimination for source of income. So because the source of income protection is included in the Residential Landlord Tenant Act, other provisions of the Residential Landlord Act apply as well, including exemptions. So while the Residential Landlord Tenant Act is pretty broad in its coverage and who has to abide by it, most residential housing, there are some exemptions, including hotels, motels, other transient lodging, housing that's provided for agricultural employees along with their employment, other housing that is provided to employees of a landlord in exchange for work that the employee does on or about the premises, other institutions such as correctional facilities, hospitals, nursing homes, monasteries, where residential occupancy is incidental to other services being provided, medical, religious, educational, or similar. So those types of residential settings would not be covered by the Washington Residential Landlord Tenant Act. However, otherwise, most other residential housing would be covered. So although it's in the Residential Landlord Tenant Act, the source of income protections are really structured, and the language is very, very similar to that in the Washington Law Against Discrimination and the Federal Fair Housing Act, if you're familiar with those. So it will list a bunch of different things that would be prohibited if the actions were taken because of the protected class, in this case, source of income. So it would be unlawful to expel somebody from real property, to discourage somebody from renting, to intimidate or threaten them, to deny that a dwelling is available when it really is, to say or write anything discriminatory in an advertisement or a conversation that expresses a preference or limitation based on protected class. So all these kinds of things are prohibited in the Residential Landlord Tenant Act now if they are done because of somebody's source of income. If they're terminated or something is stated to them expressing that their source of income is not allowed, those could be violations of the Residential Landlord Tenant Act. So specifically, a landlord cannot refuse to rent based on source of income of somebody who's otherwise eligible. So they have passed whatever other criteria the housing provider has, which may be with respect to rental history or credit. They've references, and the only thing that's different is their source of income. So the landlord can't refuse to rent to them, with the exception if the source of income is conditioned on the property passing an inspection. So if, for example, it's a Section 8 voucher that requires an inspection, which housing authorities do, then the landlord would not have to rent to this applicant if there are needed repairs or improvements that need to be made to the property in order for it to pass inspection that exceed $1,500, and the landlord doesn't take any money from the newly created landlord mitigation program account. So at the same time, the legislature passed this enactment providing for source of income protection, they also set up a landlord mitigation fund, and I'll just review some highlights about that in some following slides. So there is an exception. Landlord doesn't have to rent to somebody if they require an inspection for their subsidy, and the landlord would have to pay more than $1,500, and they don't take money from the mitigation fund. However, if they do receive money from the mitigation fund, it can be a nice helpful way for them to get some funds to make some improvements that they may need to, have been wanting to do anyway, or may need to do to be up to local code. So there is this one exemption. Now, source of income, in terms of what that is under this law, it's very broad. It includes housing assistance, public assistance, emergency rental assistance, veterans benefits, Social Security, SSI, other retirement income, and then any programs administered by any federal, state, local, or nonprofit entity. The only thing that's specifically excluded is income from an illegal source. So somebody's probably not going to be very forthcoming if they have illegal income, but it would not be protected if that was the source of the income. But otherwise, it's very broad. In terms of liability, a housing provider that violates this section refuses to rent to somebody with an alternative source of income, and otherwise is not exempted from that provision of repairs needing to be made that exceed $1,500, and they don't take money from the mitigation fund. If they're not exempted under that section, then they can be held liable for 4.5 times the monthly rent of the unit at issue, and then court costs and reasonable attorney fees as well. So this is where somebody who believes they've experienced discrimination based on denial of their source of income or subsidy would not file a complaint with the Washington State Human Rights Commission. They wouldn't file a complaint with HUD. They would likely contact an attorney. If they're low income using a subsidy, they are probably going to qualify for legal aid services representation, and then their legal counsel would file a lawsuit in court against the housing provider, and it would provide attorney's fees for that advocate, as well as 4.5 times the monthly rent and damages for the individual. So it is a different structure than other discrimination complaints under HUD or the Human Rights Commission. So in calculating income and rent, there are some things that need to be taken into consideration. This new law from Washington specifically requires that if a landlord has a income requirement, an amount of income that a applicant needs to make each month, typically 3 times the monthly rent and income is required. Sometimes it's 2 times. But if they have a level of income that needs to be met, then the voucher or subsidy needs to first be subtracted from the total monthly rent owed in determining whether or not the applicant meets that criteria. So there are a couple examples here coming up there. So for monthly income, in this example, let's say somebody has some public benefits of $333. They have some wages, perhaps from a small part-time job, $300. So they get a grand total of $633 a month. They're applying for a place that has a monthly rent of $800 a month, and they have a subsidy for $500. That leaves their tenant portion owing $300. So if there is a requirement that they make 3 times the monthly rent and income, it would be 3 times 300. They would need to make $900. In this instance, they have a deficit of $267 and they would not qualify. So in that instance, they would not be eligible. So they still need to have sufficient income to afford the unit, but the subsidy does need to be subtracted from the monthly rent owing. And then one more example. Somebody here has child support of $400 a month, wages $800 for a total of $1,200 a month. The rent is $1,000. They have a Section 8 voucher that pays $700 of their rent, leaving the tenant portion at $300. Again, 300 times 3 is $900. Their total income is $1,200, so they have a $300 above that amount, $300 above that amount, so they qualify. So that's a calculation that the housing provider needs to make if they have an income requirement. They need to take out the amount of the subsidy. So in terms of I just wanted to review a little bit about the landlord mitigation program. This was sort of the benefit, the carrot that was provided to landlords that went along with protecting source of income. So it was also passed by the 2018 legislature. It's administered by the Department of Commerce. And the Department of Commerce has a website that provides a lot of information about the landlord mitigation program. They have some slide presentations available for download and viewing on the website. And there is I believe, a form, if not on the website, available from the Department of Commerce to submit a claim from a landlord. But there's a lot of good information on their website, and I know they've been very proactive about doing education, and so they're happy to talk to landlords about this. But just briefly, a landlord can submit a claim for reimbursement if it's a private market rental unit, so housing authority units are specifically excluded, and they rent to low-income tenants that are below 80% of the median metropolitan statistical area, so below 80% of the median, and the tenant is using a housing subsidy. So the claim has to involve a private market unit, a low-income tenant that's using a housing subsidy, and that's going to be, for example, like Section 8, but it's, again, very broad, other housing subsidy programs. And it's a short-term, long-term, so very broad. The landlord can also receive $1,000 for improvements necessary to pass the required inspection. So they have to pay the first $500 themselves for any improvements, but after that they can receive $1,000. So if an inspection required improvements to be made of $1,500, the housing provider would have to rent to that tenant unless they decline funds from the mitigation program. But here they would have the option to get up to $1,000 towards that amount. Over $1,500, then they don't have to rent to the tenant unless they take funds from the program. Additionally, there's a provision where the landlord can get up to 14 days of lost rental income due to any delays or time involved in having the inspection occur. So sometimes it takes a week or so to get an inspection from a housing authority or other agency set up. And so a landlord can receive up to 14 days of lost rental income. And that's established by taking the amount of the rent and multiplying it by 12, the monthly rent by 12, and then dividing it by 365 days to get a daily rate, and then they can get up to 14 days. So they can receive $1,000 towards improvements necessary to pass an inspection. They can receive lost rental for days while inspection is occurring. Additionally, they can submit for reimbursement if they have a judgment from the tenant. They've already been to court and they have an unsatisfied judgment. They can submit for damages that occur from the tenant beyond reasonable wear and tear that have occurred at the end are determined at the end of the tenancy. Those can be submitted as a claim. And then any unpaid rent or utilities. And again, these require evidence to the satisfaction of the Department of Commerce. Typically, you're going to want to include, a landlord would include receipts, photographs, estimates, invoices from contractors, and so on. But there is a list of the kinds of things that are included, eligible for reimbursement by the landlord, and then any other property damages at the department's discretion. So submitting the claim for reimbursement, there's some specific things the landlord needs to do. They need to make sure that the property was inspected at the beginning of the tenancy by both landlord and tenant, that there was a detailed written move-in property inspection signed by both people. And then the landlord, if they want to submit a claim for damages, they would make the repairs, supply any required documentation, submit the claim on the form from Department of Commerce, and provide any additional information that the department wants. So amount of claims they have to be at least $500 for these repair type damages or other damages, unsatisfied judgments, rent, unpaid rent, but over $500 and up to $5,000. So that can be $4,500. That can be very significant. And it's probably a much faster, shorter, perhaps less expensive process than retaining counsel to go to court and pursue a tenant. However, in exchange for receiving money from this mitigation program for reimbursement, the landlord has to they have to forego their right to take legal action or pursue collections against the tenant. So if they have damages of $6,000 and they receive $4,500 from the mitigation program, they just have to let the other $1,500 go. But if they weigh that against perhaps what their legal costs might be, or maybe the time that it's going to take to go to court, this at least is a sure thing. They may not be able to collect on a judgment otherwise, and so getting $4,500 directly from the mitigation fund might be a pretty good thing. So this was obviously something very beneficial to landlords, to encourage them to want to rent to people with alternative sources of income and subsidies. So in addition to our state law, which now explicitly protects source of income, there are other bases of protections for source of income, and they're still in effect. And so I just wanted to, many of them predate this new protection, but they're in effect, and I wanted to just overview some of these. So local ordinances, of course, can protect source of income, and then we still have the Fair Housing Act and the Washington Law Against Discrimination. And while those don't explicitly include protections for source of income, if an income is so inextricably related to a protected class, for example, veterans who receive VASH vouchers that are only for veterans with disabilities, that implicates both veterans and people with disabilities, that could be a complaint under the Washington Law Against Discrimination. So prior to the Washington State Legislature protecting source of income, we already had protections under our fair housing laws if the source of income specifically relates to a protected class. And then additionally, tax credit properties are required to participate in Section 8 programs. So just taking a quick look as an example at a local ordinance, this is Spokane's. It includes many protected classes here on the screen, including use or eligibility for the use of a housing choice or other subsidy program or alternative source of income. And housing choice or other subsidy program is defined very broadly, short or long-term assistance. And then some things are specifically included, such as VASH vouchers, HEN funds, housing and essential needs funds, rapid rehousing subsidies. So all these things are protected as sources of income. And then those were protected as housing choice or other subsidy programs. And then income also is very broadly defined, which includes child support, refugee assistance, funds from a federally recognized tribe, per capita payments, housing choice payments, SSI, child support, unemployment benefits. It's very broad. So our local laws protect often from source of income discrimination. And then additionally, as I mentioned, the Federal Fair Housing Act and the Washington Law on Discrimination can provide protection for sources of income if they're specifically related to protected classes. So for example, disability income, SSI recipients have to meet a higher requirement to establish disability than the definition of disability under the Federal Fair Housing Act. Under the Federal Fair Housing Act, disability is defined as a physical or mental impairment that substantially limits one or more major life activities. And it's a much more stringent requirement that somebody has to meet in order to qualify for SSI or SSDI benefits. So if they have those benefits, they have already met the definition of disability under the Fair Housing Act. So refusing to rent to someone with SSI or SSDI, while now it's would be unlawful under our Washington state source of income protections has been unlawful under the Federal Fair Housing Act. HUD has recognized in the past and charged housing providers with discrimination for failing to rent to people who have SSDI and SSI. In the specific case listed on the screen here, the HUD on behalf of Tanisha Perkins, this one involved a woman. She was bipolar with social phobia, had disabilities. She was residing in Wisconsin, and she had income of SSDI, and she also had unemployment income. She wanted to rent a 3-bedroom single-family home in Milwaukee, and there was a for rent sign outside. She inquired about the property, and the complainant the landlord asked about her income. She replied she received unemployment and disability, and the landlord stated that he would not rent to anyone who is on disability or unemployed, because if they don't pay, he can't go after them for the money. He also asked her invasive questions such as, "What's wrong with you?" He told her he has a friend who rents to people with disabilities, but he doesn't. He provided the number of the friend, so he steered her to other alternative housing than the housing that she wanted. And in this instance, she contacted a fair housing agency. They contacted a test who called and inquired about the availability of the unit, indicating that her family received SSDI income. And again, the tester was denied because of that source of income. So the complainant brought a complaint with HUD based on not source of income discrimination, but disability discrimination. And this HUD investigated. They issued a charge of discrimination, meaning that it looked like discrimination had more than likely occurred. And before it went to an administrative law judge hearing, it did settle for $7,500, and that was in 2015. So just an example of how denial of a protected class-related income can give rise to a fair housing complaint. Additionally, people with disabilities and disability-related income have another tool at their disposal to ask for reasonable accommodations if needed to be able to access housing. So there are instances where somebody with a disability is receiving SSI or SSDI, and they cannot meet some policy of the housing provider regarding qualification. So for example, a 3 times the rent monthly income requirement, somebody with SSI or SSDI may not be able to meet that because they are unable to work because of their disability, and so their income is stuck at a set level, a fixed level that they can't go above. And so the court has, some of the courts have taken up some of these situations where people with disabilities ask for reasonable accommodations to provide some other type of assurance rather than the 3 times of rent and income, for example, offering a cosigner. So in the Ninth Circuit Court of Appeals, which is the federal appellate court for our state, Washington, as well as others in the Northwest. The Ninth Circuit addressed a situation with somebody who was not able to meet a 3 times the rent monthly income requirement. The landlord had a no cosigner rule, and this particular applicant asked as a reasonable accommodation to be able to have a cosigner, his mother, on the lease with him. And his mother had apparently impeccable credit. She'd paid off her own home. The specific applicant had great credit. I think he was even paying more rent at the prior place than this place, but they were still denied because of the no cosigner policy. And so this went up to the Ninth Circuit Court, and the court ended up holding that that it was a reasonable accommodation for somebody to ask for a waiver of the no cosigner rule because the disability precluded the applicant from working and meeting the 3 times the rent income requirement. So it's a very fact-specific analysis. There was another case in the Second Circuit that had different facts where there was an applicant who also could not meet I believe they couldn't meet the credit score criteria. And so they were proposing a cosigner, but they didn't have a specific cosigner in mind. And the applicant himself had very bad credit. And when the court analyzed his request for a reasonable accommodation, they noted that in his credit history, he had not prioritized housing. Hadn't prioritized housing or utilities, but instead prioritized other things like a luxury car or something. So the court was very unsupportive of his request for reasonable accommodation. So basically it comes down to an individual assessment that the housing provider has to assess the risk of non-payment of rent. And so they need to just look at each situation, but should not decline somebody simply because of their source of income related to disability if they're proposing a reasonable accommodation requirement. So they need to take a look at that. There was also one in the Eighth Circuit, same thing, where the Eighth Circuit court allowed a cosigner as well as a reasonable accommodation. They said that that was reasonable, and that was just in October 2018. So that seems to be a growing trend. So other protected classes can also give rise to fair housing complaints based on income and subsidies. So if a rule or policy has a disparate impact, a bigger impact on a protected class, it can be a fair housing complaint. So for example, race, sex, or familial status can also give rise to a fair housing complaint based on denial of Section 8 vouchers. HUD's done some surveys in the past that show that 62% of voucher holders are people of color, 48% of voucher holders are female-headed households with children. So some protected classes are implicated here. Any policy that says no Section 8 vouchers would have a disparate impact on these protected classes. And to give you an idea of some of the cases, we had one here a while ago in Washington State, a landlord's decision not to participate in the Section 8 program. The voucher program violated the Fair Housing Act because of disparate impact on African American women and children. They had a no Section 8 policy. Now this would be prohibited by our state law, but it could also be a fair housing complaint if you have statistics to show that the policy has a disparate impact on protected class. Another example, somebody who had a no welfare policy had a disparate impact on women's sex, and that was found to violate fair housing laws. That was in Massachusetts. And then a housing provider that refused to consider applicants if their income wasn't 3 times the rent. This one was based on race. Minority race applicants in New York asserted the policy disproportionately and adversely impacted minority populations as compared to white applicants. They made up a statistically greater proportion of those receiving fixed income government assistance in the region. Again, it's a very statistical based argument to make, but just to show you that protected classes can give rise to source of income discrimination complaints based on policies. And then the Washington law against discrimination has all those same protected classes as the federal law, but additionally has some other protected classes, including veteran and military status. And so the Washington Attorney General's office in our state has been very proactive about filing charges against landlords who refuse to accept HUD veteran VASH vouchers, HUD Affairs Supportive Housing, HUD VASH program vouchers. So if somebody refuses to accept a VASH voucher, they could potentially have Washington law against discrimination claims filed against them, as well as the new Washington law in the Residential Landlord Tenant Act that prohibits source of income discrimination. So there could be multiple claims. So that wraps up the source of income presentation that I wanted to make, just the review of source of income and the new protections, as well as how we've had prior protections that are still ongoing. And then I wanted to, as far as, because the presentation is also called Fair Housing Update, switch gears and talk a little bit about an amendment to the Washington law against discrimination regarding service animals. And so that is going to be the remainder of the presentation. So switching gears here, service animals and assistance animals, very confusing, can be very contentious topic. A lot of gives rise to a lot of misunderstanding and disputes between housing providers and tenants and their advocates trying to figure out what's permitted and what is not. And so there are several different laws and they govern different spaces, common areas, housing, transportation, and they're all different. And complicating that, our Washington law against discrimination, I indicated in the beginning of the presentation that there were a couple of key differences with our otherwise substantially equivalent state law against discrimination with the Federal Fair Housing Act. And one of the differences was the treatment of service animals. Just like temporary disabilities is different, you can give more protections under the state law than the federal law, but you can't give less. So you can protect temporary disabilities as well as permanent disabilities. So that was okay. But in this instance, it went the other way. Our state law had a very restrictive definition of a service animal, much like the Americans with Disability Act ADA definition, which applies not to internal dwelling units, but to common and public spaces. And so because of that difference, when somebody filed a complaint with HUD based on denial of a service or assistance animal, HUD would not send it to the Washington State Human Rights Commission for investigation because that part of the law was not deemed to be substantially equivalent. It was more onerous for tenants, less protective than the federal law. So our legislature did something to fix that. There had been many attempts over several years by the Washington State Human Rights Commission to get the legislature to bring our law in accord, but it actually happened in 2018, and it sort of slipped in along with something else. There was a new enactment in 2018 which makes it a misdemeanor for somebody going into public spaces, public accommodations, and passing off an animal as a service animal that is not a service animal. So there's a misdemeanor there set up for that. But in doing that, they also amended the definition of service animal under the Washington law against discrimination that now brings it in accord with the Fair Housing Act. So I just want to take a look at that for a minute. So just so that try and bring some clarity to what has not been a very clear situation. So we have the Americans with Disabilities Act, federal law that applies to public accommodations and common areas, somebody taking an animal into a store or going to the park, public spaces. And there is a very limited definition of service animal in the regulations for the ADA, and it was tightened up a few years ago, about 3-4 years ago, by the Department of Justice that enforces this. And the definition limits service animals to trained dogs, a dog that's trained to do something for the benefit of somebody with a disability. So typically you'd think of a seeing eye dog or a hearing dog, but it could be trained to do anything, but for someone with a disability, or provide a service, pick things up, provide balance, do something for the person with a disability as they're out and about in common areas, as well as miniature horses. Miniature horses were included as well in those regulations. But otherwise, no cats, no birds, no emotional support animals, no animals that are just inherently comforting and helpful for somebody's disability symptoms, but otherwise aren't trained to do something or don't provide a specific service for somebody. So it's a very, very narrow definition of disability. And our state law, Washington law against discrimination, had a very similar definition to the Americans with Disabilities Act. So it wouldn't recognize emotional support animals or service animals that are cats or other birds as companion animals, emotional support animals, anything like that. It was very restricted. In contrast, our Federal Fair Housing Act doesn't have any definition of service animal. There's no definition of service animal or assistance animal or any kind of animal whatsoever in the regulations or in the statute itself. It's simply a reasonable accommodation analysis. It's just, does the person who wants the animal in their housing have a disability is the first prong. Number two, do they need what they're asking for the accommodation? So whether it's a reserved parking space because of a mobility impairment, or an emotional support animal for a psychological disability, it's they have to need it for that reason. So disability, and then a need, a nexus between the disability and what they're asking for. So number two is they need it for the disability. And then number three, is it reasonable? And so when you're dealing with animals, it's going to be things like, has the animal been, dangerous somewhere else? Has it been destructive to the last unit where somebody lived? Those kinds of things might play into unreasonableness. But it's just a reasonable accommodation analysis. There's no definition about the animal itself. The focus shouldn't be on, does the person have a certificate for the animal? Is the animal trained to do stuff? Has it been to a specific school? Is it on a specific registry? It's all about the person. Does the person have a disability? And do they have a disability related need to have the animal? Whether it's for a psychological disability or an emotional disability, where the animal isn't trained to do anything but helps them get up in the morning, gives them some structure, gives them something living that's comforting to interact with and pet, that ameliorates symptoms of their disability. That's much different than the ADA, which has a very rigid definition of service animal. So our Washington legislature, the key phrase is down here on the bottom, this blue highlighted section. We have this was the definition of service animal is up here. This is actually a new definition. They made it really mirror the ADA definition. It was a little bit different before, but fairly similar to this. But they did include dogs or miniature horses. But again, trained to do work or perform tasks for the benefit of somebody with a disability. And then they added this little tag at the very end that says this subsection does not apply to the provisions that pertain to housing accommodations or real estate transactions. So basically they said this restrictive definition doesn't come into play when you're dealing with reasonable accommodations in housing. And so therefore that takes it back just to a reasonable accommodation analysis. And so so now we're in line finally with the Federal Fair Housing Act treatment. And so the best guidance right now on assistance animals, assessing assistance animals, comes from the HUD guidance issued in April 2003. There's been rumblings for a while that HUD may issue new guidance on assistance animals. We thought perhaps it would come out this April for Fair Housing Month, but we've not seen anything. So this is the best guidance that we have so far. And so if you don't have this and you're involved at all in either prescribing assistance animals, advocating for tenants who need them, or housing providers who are assessing whether or not to allow assistance animals as reasonable accommodations, this is really the memo that you want to get. It's available on our website. If you query on if you Google it as well, FHEO 2013-01, it should come up. And if not, I can get you a copy. But I just want to take a few last minutes of our session here this morning, and just kind of as a refresher, or if this is new to you, just walk you through how you would assess a reasonable accommodation request for an assistance animal, just because now our Washington state law is in accord finally with the federal law. So this is actually good news for housing providers. As much as they may wish that are in housing, they only needed to allow trained dogs and not cats or emotional support animals. It was very confusing having two different structures, our state law and our federal law, not agreeing. And if they happen to consult somebody for advice that only knew about the state law and not the federal law, it could really set them up as a trap for the unwary to tell somebody that no, they couldn't have an animal because it was a cat, or it wasn't a trained service animal, or didn't have a certificate or something like that, and could end up to violations of the fair housing laws. So now at least the state law is the same as the federal law, so hopefully everybody is giving the same information now and getting the same information in training, so that everybody's on the same page. So just want to take a few minutes and walk through how you would assess a reasonable accommodation And this is all based on, you'll note down there, the FHEO 2013, strictly from this guidance memo. So neither the Fair Housing Act, or there's also Section 504 of the Rehabilitation Act that provides, that covers housing that receives federal funds. So that also requires housing providers that receive federal funds to make reasonable accommodations. So neither the Fair Housing Act or Section 504 require that an assistance animal be trained or receive a certificate. Now, training doesn't have to do with behavior. It needs to be well behaved, not running all over the place, barking all night, or jumping up on people. But it doesn't need to be trained in terms of being a service animal, have gone to a school or anything. Some people get that training for their animals, some don't, but it's not required. And then, unlike the ADA, the Fair Housing Act allows people to have emotional support animals, and animals other than dogs. They can have cats, birds, something else if it's not prohibited by zoning or ordinances of the jurisdiction. Breed, size, and weight limitations may not be applied to an assistance animal. Again, this is from HUD. So while a housing provider can have rules regarding pets for people without disabilities, so they could say no animals at all, cats only, dogs only, 30 pounds only, whatever they want to do. But if somebody with a disability asks for a reasonable accommodation for an animal that is outside of the breed, weight, or size requirements of the housing provider or species requirements, their reasonable accommodation request needs to be considered. So the fact that the animal might be a pit bull shouldn't automatically exclude it as a reasonable accommodation. Now, housing providers will say, but what about my insurance? We have a dangerous breeds policy. And there is a memo for that from HUD, from Brian Green, and I believe it's from about 2006. But it's a 2-page memo, and it basically says that if a housing provider would lose insurance or can't get comparable insurance because of accepting a dangerous breed, then it's an undue financial hardship. So it wouldn't be a reasonable accommodation to make. You can't operate without insurance. However, it's an affirmative duty on the landlord to check. They can't just say, oh, my policy says that, or I think it says that. They would actually need to shop around with their agent. Can I get alternative insurance? Is it going to be significantly more? What are my options here? Do something to show that they're not just resting on, nope, we can't take it because of the breed. But the memo does conclude that insurance companies are protected by, or are covered by, the fair housing laws. You'll recall I said the Fair Housing Act applies to sales, rentals, lending, appraisals, inspections, insurance. So it covers insurance. So the memo says that insurance companies that don't make reasonable accommodations for people with disabilities will be referred to Department of Justice for investigation. So that can help you often if you are working with a housing provider and or their insurance company that is prohibiting an assistance animal needed for a disability that happens to be a breed different than what's allowed in the housing. So sum and short of it, just because it's a pit bull, it could be prohibited if it's just somebody's pet, but if they are claiming they need it as a disability accommodation, then you just need to go through the regular analysis. Do they have a disability? Do they have a need for the animal? And then is there anything unreasonable about it? HUD says you can't make assumptions that the animal, because of its breed or whatever, is going to be dangerous. You can't speculate. If there's known information about that specific animal, that's what comes into it may be unreasonable to allow it. So accommodations or exceptions to rules or policies so that somebody can enjoy and access their dwelling. And the analysis is just quite simple. Is there a disability? Is there a nexus between the disability and what they're asking for? And then is the request reasonable? So this gets applied whether somebody's asking for a reasonable accommodation for an assistance animal, or for a reserved parking space, or a live-in caregiver, or to transfer units from perhaps an upstairs unit to a ground floor because they can no longer do the stairs as well because of their disability. They may need to get out of a lease early to go into assisted living, to move to a location that's closer to some kind of treatment they're receiving, to move in with family who can care for them, or to be closer to family. But if there's a disability related reason for needing to break a lease early, they could ask for a reasonable accommodation for that, without financial penalty, without having all the remaining months of the lease assessed against them, which otherwise would be permissible. They can ask for an extension of tenancy. If they've been terminated with a 20-day notice, but they need more time for a disability-related reason, they may be able to ask for some extra time if there are no cause reasons that the tenant needs to be out sooner. So again, this is applied to assistance animals. So first, the person has to have a physical or mental impairment which substantially limits one or more major life activities. And that can be determined either by discerning, is it obvious? Some people, if you're in a wheelchair, if you're using a red and white striped cane, HUD would say don't make the person go to the doctor to get a letter saying that they have a disability. You can take it at face value that they have a disability. But because many disabilities are invisible, housing providers have a right to ask for third-party verification of the disability. So I'll get to that in a minute. In addition, there needs to be a disability related need for the animal. So this is the second prong. So if we're talking about an animal as an accommodation, it needs to be needed for the disability. So that's generally going to come under one of two criteria. One is kind of your traditional service animal. Does the animal work or perform a task or service for somebody with a disability? And then two is more like your emotional support animal. Does the animal provide emotional support that alleviates one or more of the identified symptoms or effects of a person's disability? So if you are a healthcare provider or working with a healthcare provider and writing prescriptions, this is some language that you may want to consider. You may want to set forth that the person, yes, has a disability as defined by the Fair Housing Act, without telling what the disability is. Don't need to disclose medications, diagnoses, symptoms. Just this person meets the definition of disability and therefore needs, is required to have, is prescribed, X, whatever it is. In the case of an animal that provides support that alleviates one or more symptoms of the disability, or provides a task or work for the person with a disability. So verification for the housing provider. If it's obvious, they don't ask for verification. And if it's not obvious, they can ask for verification of the disability and the need, but they can't ask for access to medical records or to medical providers. So they shouldn't be calling up the doctors, even though they do. And the doctors, because of HIPAA laws, shouldn't, without a release, hopefully be sharing information with them about someone's disabilities. But HUD specifically says in its memo that housing providers should not ask for access to medical records or medical providers. So if there is a problem with the verification that's being presented, it's unclear, it's ambiguous, it's not clear that the animal is needed or prescribed or required, then the housing provider should put the onus back on the person asking for the accommodation to go back to their provider and determine if they can get a revised letter or not. So the housing provider should just say, we grant reasonable accommodations, we review them, we assess them, but this isn't clear that you need what you're asking for. But if you provide something else, later we'll consider it. So rather than calling up the doctors or the doctors sharing information about the disabilities of the person, it should be a discussion between the actual person with a disability and their doctor as to whether or not it's needed and whether or not the healthcare provider is going to provide documentation of that need. As examples of who can provide the verification, it doesn't need to be an MD doctor. It doesn't need to be a doctor at all. It can be a physician, a psychiatrist, a social worker, another mental health provider. There's another memo from HUD that's not specific to assistance animals. It's from 2004. It's joint guidance from HUD and Department of Justice on assessing reasonable accommodation requests, and that also discusses who can provide verification of a disability, a third-party verification, and it's very broad. It's basically anybody who's in a position to know about the functional limitations of someone's disability. Could be a social worker, a peer support group. It's very, very broad, but the closer to the person, if it's their neighbor, if it's a family member, likely an investigator is going to deem that person, while they may be well informed of the limitations of the person's disability and need for using whatever the accommodation is, they're going to be deemed to be more biased and less credible in an investigation. But very broad in terms of who can provide verification of the disability. And then the last prong, reasonableness, again gets to, is that specific animal a threat? Is there evidence it's done something dangerous before? Or if not, then the housing provider needs to allow an assistance animal as a reasonable accommodation. If it's needed and there's a verified disability, then they need to allow it. But once it's in housing, it doesn't get to just run rampant. It should be well behaved. There's going to be an occasional bark or something probably, but shouldn't be going on at all hours of the day and night. Animals shouldn't be aggressive, should be under the control of the person, which typically means on a leash or in a carrier or a cage, unless exceptional circumstances such as somebody who's not able to have the animal on a leash because of their disability, but it's under great voice command or something like that, that needs to be picked up after. The person with the disability needs to make arrangements to have the waste picked up if they're not able to do it themselves, and is responsible for any damage that occurs to the unit. The housing provider can't ask for a pet deposit or fee ahead of time. They can do that for pets, but not for assistance animals. But if the animal ends up damaging the unit after the fact, then that can come out of a security deposit or damage deposit, or the tenant would be responsible otherwise. So that concludes the information I have for you today about source of income as a new protected class under our residential landlord-tenant law in Washington, and how it can also be a Fair Housing Act or Washington law discrimination complaint if certain types of subsidies or income are denied that are related to protected classes. And then it's important as an update this year to know that the legislature in Washington finally brought our state law against discrimination into alignment with the Federal Fair Housing Act's treatment of assistance animals, which, by the way, HUD just uses the overarching term assistance animals. They don't differentiate between service, emotional support, companion animal. The focus is on, does the person have a disability? Do they need the animal for their disability? But that's an important update so that hopefully everyone will understand now that the kinds of things that are applied in common areas and on airplanes and don't apply in housing. It's a much different analysis. Reasonable accommodation, not a focus on is the animal trained or have a specific certificate. So I'm open to any questions that people want to. I see one question there. Can we please get a copy of the slides? Yes, I will provide a PDF of the slides to Amanda, and I believe she will make that available. I'm not sure through email or through the Washington Healthcare Authority's website, but you should get access to the slides. And I believe a recording is also being made, so that's going to be made available too, I think, through YouTube. I'm open to any other questions. And Amanda, are you there? I can't hear her, so I'm just looking at the chat section to see if anybody else has any other questions about source of income or assistance animals or any other fair housing related matter. I'd take that. I'll give you a minute or two to see if anybody wants to type anything in. Otherwise, if you have questions or want more information about fair housing, our website address is up, nwfairhouse.org, and we do have quite a few resources on there. My contact information should be on the webpage as well, but my email address is execdir, EXECDIR, @nwfairhouse.org. execdir@nwfairhouse.org. I'm happy to answer questions as you encounter potential fair housing issues along the way. So thank you very much for taking the time out of your morning to learn about our state and federal fair housing laws. And I wish you a good day. Thank you.